All right, well, let's go ahead and get started. Thanks for having me on today. My name's Walker Terry. I'm an attorney with Byrne Canaan Law in Richmond, Virginia. We are a healthcare defense firm that focuses on defending physicians, nurses, and other providers in malpractice litigation, as well as administrative matters. I'm going to be talking to you all a little bit today about AI and the emerging role of AI in healthcare, and specifically implications that has on malpractice litigation. So we shouldn't be here too long today, but I did want to start off by giving you just an overview and roadmap of what we're going to be talking about. I'm going to begin with a general discussion of AI and its evolving use in healthcare. We're going to go over some examples of AI-related healthcare litigation that we've seen to date on a national level. Then we'll move into talking about how the emerging role of AI is likely to affect malpractice litigation. And then we'll end with a few risk management thoughts and strategies that might help as AI becomes a bigger part of all of your practices. So what is AI? I admittedly am not an expert in technology, but what I do know and what's out there is, obviously the term or the acronym stands for artificial intelligence, but in general, it is the sort of next generation of computer and computer technology. And the goal is to go from sort of linear programming where computers are programmed to do a specific thing and that only, to a more integrated approach that allows a computer to behave and process information much like a human brain, and doing that specifically by processing and studying large data sets, identifying patterns in those data sets, and then applying those to new data that is provided in the future. Some sort of key terms or buzzwords you might see if you're looking at AI online or reading material on it are listed here below. So the first one is machine learning, which kind of refers to the broader concept that I just discussed, where you're going beyond express programming of specific and discrete functions and commands to where a computer program is able to actually process new information and spit out an answer based on what it's learned in the past. You'll also see the term neural networks, which is sort of a digital equivalent of a neuron in the human brain. So think multiple computer systems or devices working in concert with each other to give a certain result or provide certain data. And then finally, deep learning is the more specific concept I talked about earlier, where it's sort of the primary function of AI that allows it to work, which is having computers process and really networks of computers process huge volumes of data and then using that to new data sets moving forward. So some additional terms that you're likely to see with regard to specific functions that AI can perform. One is computer vision. So you have computer systems that are able to recognize images, faces, etc., and respond to that. Similarly is natural language processing. You'll see a lot of AI tools that are able to process, respond to, and provide responses and new information to natural language that's either spoken or written in. And then another term is advanced algorithms, and these are the actual sort of nuts and bolts of how AI typically works. So these are the systems that are applied to allow AI to learn, integrate, and apply knowledge that is provided. So a tagline that you'll probably see out in the world regarding AI right now is that the goal of it is to reason on input and explain on output. So you input data to AI, the AI system reasons through it, and then it provides an explanation, or in the healthcare context, a lot of times a recommendation to you on output. Another line that you'll see, and this will become important in a few minutes when we start talking about AI and litigation, is that at least at this point in time, AI is only there to assist human beings. It is not there to replace us in anything that we do, including our roles in the healthcare industry. So some examples of AI you've likely seen in your everyday life that aren't specific to healthcare are listed here. Maps and navigation programs that we all use on our phones and our cars, et cetera, are programmed by a version of AI. Um, Facial recognition and image recognition software is often used in as a security measure. You have this on your phones and tablets. It's how you can. It's a method you can choose to access those. You, a lot of us have or utilize text auto correction programs. We have this on our phone and also in our word processing programs. Recommendation algorithms you see a lot in search engines based on prior searches from a specific user. You'll see suggested searches and suggested websites to visit. Chat bots are interactive tools that allow us to communicate with a computer, ask questions, provide information, and then the chat box provides a response within a limited range of topics. And related to that are task assistants like Siri that everyone is familiar with at this point. So AI in medicine specifically, you see a lot of those similar concepts that you see in everyday life are starting to pop up in healthcare specifically. So there's a lot of AI tools that are used in sort of back office functions at medical practices and groups. You see a lot of AI tools in the assistance of, or used in the assistance of billing and scheduling. You see a lot of note-taking programs and text autocorrection, autofill data. This is becoming commonplace in a lot of EMRs already, where you have drop-down menus that are used in stock language that is used instead of having a provider write in everything. But over time, that's going to be more commonplace, I think, in throughout the clinical practice, and allowing a program to fill in your notes for you, even with regard to a specific patient. But you also see, and then there's also, you're starting to see chatbots specific to healthcare providers. They're acting much like a desk reference or medical literature. So instead of having to read something to get sort of foundational medical information about a condition, for example, you can use a chatbot to do the same thing. And you're also starting to see much more advanced AI tools in medical practice that really helps with actually the clinical side of things. So two examples that are I think most prevalent out there are radiology assistance tools that basically work by using big data sets of prior imaging studies and looking for patterns and identifying potential abnormalities, things like areas of cancerous or precancerous findings, and then directing the reviewing physician to an area on a new study that includes a similar type of pattern. You also see a lot of AI tools, or you're starting to see AI tools in actually the development of treatment plans for individual patients. So using data sets and prior data from individuals, these programs can help us physicians formulate a treatment plan by proposing possible diagnoses, treatments, further testing, and medications that might be used. And so this slide just goes over a little bit more what I just talked about with some of these diagnostic aids with imaging and treatment plan formulation. So with AI in all contexts, including healthcare, but not exclusive to healthcare, there's a number of concerns and potential legal concerns that are sort of on everyone's mind. One of them is privacy, and this is particularly pertinent to healthcare. And as we'll see in a minute, there's already been some litigation on a national level about this issue. So because a lot of AI tools are built based on existing data, and if we're talking about a medical context, that is data from actual patients, there's a huge concern that data is made anonymous and that it remains anonymous throughout the building process. Obviously, with any sort of technology, cybersecurity is also a concern. There's always a threat of hacking and nefarious and criminal activity out there. Another concern, which I think is probably an issue in a lot of industries, but certainly healthcare, is the reliability of the technology itself. AI is constantly evolving and changing, and with a new program or system, it doesn't always have all the problems and kinks worked out yet. And um, unfortunately, a lot of times those problems don't become evident until they cause a problem. So with any sort of new program, this is always a concern. There's also a good amount of information out there about potential biases that are sort of baked into the AI tools. And it isn't something that is typically intentional, but the data sets um, are only going to include the populations that they include. So if a tool is programmed based on data that excludes a certain group or a certain patient population, then that tool is arguably not applicable to that group or may not be as accurate when applied to that group. And then obviously the question that we're all here about is liability. If something does go wrong in the use of AI in healthcare, where does the liability fall? What are the potential claims and legal theories that a plaintiff might make? And how do we respond to those and defend them? So kind of expanding on that, a couple points that I thought of that make liability a sort of unique issue with regard to AI is the as I said a minute ago, the sort of ever evolving and rapidly changing nature of it. And in the legal context, the problem with that is that a lot of times the law doesn't have time to catch up to it. So in any sort of litigation, you're applying, statutes and regulations. You're also applying legal standards and frameworks for causes of action that are established through case law. And the overarching principle in legal practice is that we use and depend on precedent. And so once something is established in the case law, that becomes the law moving forward. When there's a new technology that doesn't match for whatever reason with the standards that we have, that can become a problem because the law has to evolve and respond, and there might need to be a new standard that is created to address liability based on malfunctions in AI. But there's definitely going to be a period in which that standard doesn't exist and the cases are ongoing. So that presents a complication. Um, Another thing that you'll see if you look into AI generally is that, or AI in healthcare generally, is that AI in general, as a form of technology, is not subject to as many regulations as other healthcare products as a general matter, which are, as you all know, highly regulated. So the disconnect there, it may be a complication moving forward. And as I mentioned earlier, like with any new technology, if there are problems that are sort of baked in, um, people are likely unaware of them until they actually produce bad outcomes. So you're kind of working backwards, unfortunately, in a lot of these scenarios. So if and what I wanted to talk about primarily today is how AI is going to affect malpractice litigation against individual providers. So as we'll get to in a moment, a lot of the litigation that's been reported on publicly, at least to date, hasn't had to do with this. It's had, we'll get to it later, but it has to do with a lot with healthcare insurance and claims related to privacy in the building of AI tools. But at least I haven't seen in my practice to date any claims in which a bad outcome occurred, AI was used or relied upon during the treatment, and then that became a central question in the litigation. That likely will happen eventually. And so when it does, there's a couple of questions as to how those claims are going to be uh, phrased and formulated and who is going to be on the other end of them. So if a patient has a bad outcome and they are informed that an AI tool was used in their treatment and they can attribute their bad outcome to something having to do with the AI tool, whether it was an error or a misapplication or what have you, who are they going to put on the other end of their suit? Is it going to be the healthcare provider who relied on the tool too much and at the exclusion of other objective information or their own judgment or consulting with colleagues or specialists? Are they going? Is the primary target going to be the reverse of that, the healthcare provider who declined to rely on an AI tool that has been shown to be useful in prior cases? is are there going to be claims about not providing patients enough notice and enough information about the role of AI in their healthcare? Or alternatively, are the manufacturers and distributors of the products going to be on the hook? So those sort of diverging theories are going to complicate how lawsuits are litigated, because as we'll get to in a moment, a medical malpractice claim has very specific elements, and I don't I don't do a lot of products liability, but a products liability claim has very different elements, very different things that need to be proven. And so you're going to see different types of cases depending on what theory they use. And you might even see hybrid cases where you have providers involved as defendants as well as manufacturers. And another point that I think I'm going to bring up a couple of times in our remaining time is that right now, at least, the AI tools that are available require a great deal of human input. So regardless of what they are, the tool is doing, it's going to require a human being to provide the data that the tool then uses. And then it's also up to the human provider to decide what to do with the recommendations and results that come out. So for that reason, I think it's unlikely that you're going to see a lot of litigation against the manufacturers of these tools that leave the users completely out of the picture. But as technology becomes more and more advanced, that could theoretically change. So here are just a few examples of some cases involving AI in healthcare that are in the news. So two of the big ones have to do with, these are class action cases having to do with health insurance companies. One is the Sparrows et al. Versus Humana. I don't have the site, but there's a similar case involving United Health. And these cases involved administration of Medicare Advantage plans. And the claims and the allegations are that the carriers denied coverage for certain care. I believe it was primarily acute care or post-acute care rehab type services, and they denied coverage, at least after a certain point, based on the use of an AI tool that made predictions about how long those services would likely be needed for certain patients. And so one of the allegations is that program was known to be erroneous, or have a high error rate, I should have said, and also that the recommendations that were being relied on were in contrast to recommendations that were coming from some of the patient's physicians. So and I don't know the current status of these cases, but this is what is out there, that these cases have been filed and that these are the general allegations. I don't know the truth or falsity of any of the claims, but that's what the patient is at least alleging. And the carriers, to be fair, are fully pushing back, denying this, and defending the cases. And they're what statements I've seen from them that are out on the web are that sort of downplaying the reliance that was placed on these programs and saying no, these insurance decisions, coverage decisions were based on the objective language of the policy and that type of thing. So another case that's come up recently was actually ultimately dismissed, but it's still an interesting one and worth noting, is this Dinerstein versus Google and the University of Chicago Medical Center. So the allegation there was that the university provided a lot of data set or a large data set to Google to build or contribute to an AI tool. And the data was anonymous when provided, but the claim was using other data that was available to the provider, to Google, that the data could become de-anonymous or de-anonymized. And so there were a number of theories advanced in that case having to do with breaches of privacy, through agreements or privacy notices and privacy terms that the two defendants have put out there. As I've noted here, the case was ultimately dismissed for a lack of standing, but it's worth noting because this, as I said earlier, this issue of privacy is a concern with AI, and you are likely to see similar types of claims come up in the future involving other providers. And then this isn't a case, but is something that is a recent development. So the Department of Health and Human Services Office of Civil Rights just published a new final rule in July of this year, which explicitly prohibited discrimination in specified healthcare activities. And one of those was the use of certain AI tools and algorithms. So as I was mentioning earlier, there are allegations of this as well, that either through the building of the platform or the data used, there certain patient groups are not included or are not fairly represented. And so the results that you get are skewed to either exclude or give um, inaccurate results with regard to a certain group. So let's turn now to, as you can see, these cases don't really involve individualized malpractice claims. So I want to talk a little bit about how further developments in technology are likely to affect malpractice litigation. So to give a kind of brief refresher and overview of a malpractice case, um, this is a professional negligence theory. So in any negligence action, whether it involves a healthcare provider or another professional or something else altogether, there are four things that the plaintiff has to show. They have to show a legal duty owed by the defendant to the plaintiff. They have to show that the defendant breached that duty. They have to show that they suffered harm, and they have to show a causal link between the defendant's breach of the duty and their harm. So a really simple example of this outside of the healthcare field or arena is a car accident case. So anyone who gets behind the wheel of a car has a legal duty to drive in a reasonably safe manner, which means at minimum that you have to follow traffic laws and traffic signals. If you fail to do that by running a red light, speeding, or not paying attention, you've breached that duty. If an accident occurs and the occupant of the other vehicle is injured and they can show that accident and injury resulted from your running the red light or speeding or what have you, which is usually pretty obvious, then they've established a negligence claim. So it's the same general formula in medical malpractice, but the breach or the duty rather that's owed by the healthcare provider to the patient is called the standard of care. So this is a legal term of art, but what it means is it is a duty owed to act as a reasonable practitioner would act in the same or similar circumstances as those presented in the case. And there's three kind of caveats to that. So the first one is that the standard is, like I just said, it's one of reasonableness. It is not the standard of care does not require perfect care. It does not require a beneficial or optimal outcome. It just requires that you behave reasonably. So if a reasonable physician, and it doesn't have to be every reasonable physician, but if a reasonable physician would have done what you did, then you've satisfied the standard of care. The second caveat is that the standard of care is technically jurisdictional specific, at least in Virginia. You need to show that it's what a reasonable physician in this state would do under the circumstances. Now, granted, that particular caveat is rarely a defense point in malpractice litigation as it stands right now. Most experts and those that testify about the standard of care will say that the standards regarding pretty much any procedure or treatment that I've seen at least is a national standard. It's not specific to Virginia or California or anywhere else. But it is still there as a potential caveat or defense point. A third one is that it is specialty specific. So it is what a reasonable, whatever the defendant's title and specialty is, would do, not what a reasonable physician in another field would do if the defendant is in one specialty. And it's not what a reasonable doctor would do if the defendant is not a doctor but is a nurse or a nurse practitioner or what have you. So this caveat is often a defense point because you can have the standard of care with regard to assessment and consideration of, for example, a sort of obscure condition or diagnosis is different and might be higher for a physician that is a specialist in the field related to that. So if we're talking, then it would be for a generalist, for example. So if we're talking about a patient who has a really off the wall and rare neurological condition that presents with certain symptoms, and those symptoms are indicative of that, as well as a number of other things, the standard of care might require a neurologist to consider that condition and include that on his or her differential, but that might not be the case for a primary care doctor or an emergency room physician. The fourth caveat is that in Virginia, and I believe in most states, the standard of care needs to be established and there needs to be evidence about what it is and whether or not it was breached through the testimony of an expert. And an expert is a peer to the defendants, a licensed physician in the physician specialty or related specialty that has knowledge of what the standards within the industry are with regard to the particular condition at issue. So if the plaintiff can't get an expert who's qualified to support their case, they can't pursue a case. And while the defense isn't required by statute, like the plaintiff is, to have an expert witness to defend the care, it is, as a practical matter, necessary to have that. So these cases hinge almost always on competing expert testimony. So the question is going to become how the introduction of new technologies into medical care and then down the line into medical malpractice suits is going to affect this framework that's been established for decades surrounding medical malpractice. So I think that it's going to depend, that the answer to that question is going to depend on the theory that the plaintiff alleges. So we talked about this a minute ago, and there's basically two major ways that this can go. Either they can argue that AI was used and too much reliance was placed on it, or they can argue that AI wasn't used and that more reliance should have been placed on it. I think at least in the foreseeable future, you're going to see the first theory more than you're going to see the second. So the first theory being that you relied on AI too much. I say that for a couple of reasons. One, that's been the general theory in some of the litigation we've seen to date. That was the general claim in the cases involving health insurance carriers we just discussed. There's also data and anecdotal evidence out there to suggest that the public is, and I don't think this is surprising, there's a lot of sort of skepticism surrounding AI and new technologies. And I think that skepticism is heightened within the healthcare field, where people are making really important decisions involving people's lives and their health. And so I think you're going to see more claims about physicians and other providers who used an AI tool that perhaps wasn't reliable, or their reliability of it wasn't known, perhaps because it's so new, and they didn't follow up on whatever information that program gave them with their own sort of double checking. I think that's going to be what you primarily see. When you start to see the reverse of that, which is, claims that there's an AI tool out there that would be really helpful in, for example, identifying the cancerous region on a scan, and that should have been used and it wasn't used, and if it was used, you would have had a different outcome. The cancer would have been detected. I think from that perspective, as the provider, you have a number of defenses under the framework that we talked about a moment ago. So number one is that in the beginning, I think that the jurisdiction, or more, or not so much the state, but the region is going to be an issue and is going to be a potential defense point. So as technology comes out and is sort of cutting edge, it might be commonplace at big academic medical centers, but it might be prohibitively expensive or not within the practice of rural physicians and smaller practices. And that may be a legitimate point that you can get expert support for. So again, the standard is reasonableness. If it's going to cost an arm and a leg to purchase a program and you're not going to use it, but so often, there's a strong argument that the reasonableness standard doesn't require you to burden yourself with acquiring that tool. I think as a similar point, the specialty requirement is going to become an important caveat in these cases, because a specific tool may be utilized within a specialty or subspecialty because the range of what those doctors are treating might be smaller, and so it makes more sense for them to purchase a certain tool, or at least to use it enough that it becomes part of their standard practice and they become more familiar with it. That argument may not be the case in for a generalist, a PCP, a pediatrician, a ED doctor. And so I think you're going to see plausible arguments from defense experts on that point, that the reasonableness standard doesn't require a PCP to use certain AI tools the same way it might require a neuroradiologist to do so. I think you're going to see some questions on the qualification of expert witnesses with respect to this. I think that if, for example, you have an expert witness who doesn't have a lot of experience with the particular AI tool that is at issue in the case, you might see some challenges to that expert's qualifications. Generally speaking, if the doctor is within the specialty of the defendant, or they're within a related field and they have knowledge of the condition or the treatment at issue, they're going to be allowed to testify. If the central part of the case is a technology and there's someone who has no experience with it whatsoever, you might see different rulings on that. And then the final point is just the standard of reasonableness. I think we are a long way away from a point where any sort of AI tool is so commonplace that it is unreasonable, or that you can make a plausible argument that it is unreasonable for you not to use it, or for you not to use it in any particular case. So I think, like I said, I think when you start to see this pop up in litigation on an individual basis, what you're more likely to see is claims that AI was relied on too much. A related point in malpractice claims, as I mentioned a moment ago, there's always a causation requirement whenever you have any sort of negligence case, and that's also the case for medical malpractice. And a lot of times, causation is a big point. It's a big disputed point, and one that you can build a strong defense on in and of itself. A lot of these cases have to do with people with really serious or terminal medical conditions, and you may have a plausible argument that even if the defendant failed to provide necessary treatment, or failed to provide it at a certain time, that the patient was in such bad shape that it wouldn't have made a difference ultimately. And so I bring that up because there might be a temptation to make similar arguments with regard to AI. For example, saying, if there was an error within the program, the outcome was only the result of that error, and it wasn't the result of anything that the provider did or didn't do. I will say, I think that argument is going to be a tough one to make, and a tough one to prevail on. And the reason for that is that question and that argument has to do with what's called legally a superseding cause. So the causation bar is not very high, excuse me. And so if the plaintiff can show that the actions of the defendant in any way brought about their bad outcome, they've established causation. And there can be multiple of those proximate causes. So if there are multiple, and this is common in litigation, there's multiple defendants, multiple providers, they all saw the patient at certain times, they all allegedly should have caught something or diagnosed something or made a certain referral, and none of them did it. Because, arguably, any of them taking the action that the plaintiff is saying they should have taken would have prevented the result. They're all a proximate cause. The only time that is not the case is if you have an event that completely supersedes any negligence of the defendant. So and that's what it's called. It's a superseding cause. And I will tell you that it's rare that you would even get to argue that at a trial or give the jury an instruction on it, because the law, at least here, is that the superseding cause, whatever it is, has to completely sever the causal chain from the defendant's negligence prior to that superseding event and the ultimate outcome. So you might think that might be a defense whenever you have different providers treating the same patient at different points in time, and the patient dies or has whatever complication after the final physician's involvement, but that's not how it typically works out. The Because again, the argument is if anybody, if the first provider had done what the plaintiff is saying they were supposed to do, then the third provider wouldn't have even been involved and their care wouldn't have been relevant. So if anyone had the opportunity to intervene and help and they didn't do that, their inaction is viewed as a proximate cause, and they're potentially liable. So the way this would pop up in the context of AI has a similar problem. So if an AI tool is going to require the physician to input certain data, and more importantly, it's going to require the AI tool isn't going to make the final call for the doctor. It's going to give a recommendation, and the doctor has to decide whether they're going to adopt that or not. And so there's no, you're not going to be able to say that the final event that led to the outcome was the error of the program. The final event was what the human defendant did with that information. So given that, I think I wanted to end today with a couple tips about ways to manage risk when AI becomes a part of your practice. And so there's a couple of key points. And those include disclosure, documentation, and consent. And documentation is perhaps the most important. Documentation is key in defending any medical malpractice case. Some people say that if it's something isn't documented, that it didn't occur. Of course, we know that's not the case. The medical records are always limited in some way, and there's always a conversation or a thought process or a consideration that happened that isn't written down. But the more you can document, the better, because for the simple reason that these cases take a long time to get off the ground. The patient has in Virginia, has at least 2 years to file a case following whatever treatment they're challenging. And physicians and other providers see a multitude of patients every day. And so it's very common that when litigation ensues, you simply don't remember the specifics of what you did with one specific patient's 2 to 3 or more years prior to that. So for that reason, documentation is key to your defense. And so it's also key in sort of confirming certain facts. And that's where it's going to be particularly important in AI. I think that when AI is used within an organization, that a helpful risk management tool is to first and foremost make sure that everyone in the organization is informed and on the same page about what tools are available, what they're used for, what they're not used for, when they're expected to be used, and when they're not expected to be used. I can tell you it would be difficult to defend any decision regarding a technology tool if that decision isn't consistent. To the extent it can be. Of course, every patient case is a little different, but the basics of when you utilize something should be pretty standardized. Another point is that I think it's going to be important to document, as to the extent that you can, how the AI tool is used. So why you decided to adopt it or use it rather, what data you provided to the program, what recommendation the program provided to you, and what you did with that information, whether you decided to go with the recommendation from the computer or not, and in either case, why you made that decision. And then a final point that relates to this issue of disclosure actually ties into a sort of subset of medical malpractice claims, which are consent claims or lack of consent claims. So you all know that obtaining a patient's consent is critical in any scenario. And if there's an allegation that the doctor did something to a patient that the patient didn't consent to at all, that's actually, at least in Virginia, a battery theory. It sounds strange. A battery is an unwanted touching, usually a physical assault, but it's the same idea. The provider has touched and your body in some way and manipulated it in a way that you didn't know they were doing. And so if you disagree with that later, you have a plausible claim for battery. That is distinct from a claim for lack of informed consent. where the theory is that you were told what the physician was going to do, but you weren't given sufficient information about it. So here the standard is that if again, it's a reasonableness standard, if a provider does not provide sufficient information about material risks involved in a certain treatment course, or if they don't advise the patient of reasonable treatment alternatives, and the patient decides later that they would have chosen a different course or declined treatment had they been given more information, and they suffer a bad outcome as a result, they have a claim. They have a negligence claim under a specific theory of lack of informed consent. And so that is definitely something that you may see regarding AI, particularly given public skepticism of it in general. So as this becomes part of your practice, the question of what you need to disclose to the patient about what tools are going to be used, how they're going to be used, the limitations of that tool, the potential risks of the tool, whether there's an error rate or there's an unknown error rate, or the reliability depends on certain data that you may not have in a particular case. And then whether the patient has an option to forego the use of that AI technology and maybe use a more traditional method through other, healthcare tools or involving more human being providers. Maybe that's an alternative to whatever the AI tool is going to make more efficient for you. It's going to be important to decide what the patient needs to know and what is likely to affect their decision. Informed consent law does not require you to disclose every treatment option under the sun or every conceivable risk. It has to be, a plausible, reasonable treatment alternative likely to bring about the same result. And it also has to be, the risks have to be material, and they have to be ones that wouldn't be obvious to everybody. So there are caveats, but technology, AI is ever evolving, and most people in the public don't know that much about it. So I think in deciding what you need to provide in terms of information to patients with regard to AI assistance, I think you're going to need to be a little bit more cautious and disclose a little bit more as this becomes a part of everybody's practice. But for now, I think the primary takeaway is simply that when you do use these tools, be aware that they have limitations. And error rates aside, the limitation is that they don't replace you. They're meant to make your practice more efficient. They're meant to be informative. They're meant to help you, but you are still the provider, and your decisions and your judgment call is what should drive treatment. And if you stick by that, that's going to be the most helpful thing you can have in defending a case that might involve this. So that's what I had for today. I think we're about at 40 minutes, 45 minutes. So thank you all very much for your time. It's been a pleasure being here. And I put my contact information up on the screen now. I'm happy to answer any questions that you have about this topic or others. Feel free to reach out. Thanks so much.